Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about Estate Planning 101. Before I get to that though, I want to remind you, if you have questions related to this or anything else estate planning related, you can go to estatemeeting.com, set up a time to talk with us over the phone for free, estatemeeting.com. Okay, Estate Planning 101. I like to do these little training videos with some kind of an overview of estate planning every once in a while. I've done them in the past, but I understand that some of you either have not been in my world before or don't want to go back and try to find this type of video. So here it is. I always, when it comes to estate planning, I had to talk to a potential client this afternoon, and he asked me what's a great question to lead this in, which is, who should have an estate plan in general? The answer is everyone. The reason why everyone should have an estate plan is different. There are different things that are going to matter to different people, but basically everyone should at least have the essential items in an estate plan. And I think it's probably easiest if we just kind of go through those things, talk about why they're important, why people might want to have them, and then just wrap this thing up. Okay, so to begin, estate planning really covers you in two circumstances. This is something that people often don't consider. Number one is when you are alive but incapacitated. The other side is when you are dead. Obviously, everybody thinks about that dead side when we talk about estate planning, but the alive but incapacitated side is something that people often forget about, and that is the part that often comes to bite you. We also often think when it comes to estate planning that we are trying to protect our family, we're trying to protect our legacy, trying to ensure that our children or that our loved ones receive the assets that we want them to get. But estate planning is also about protecting you, okay? That's what the power of attorney does. That's what the medical power of attorney does. What you basically have the ability to do is name the person that's going to be in charge of your finances, going to be in charge of your world, if you are unable to make decisions. Often this happens toward the end of our life when we, if people develop dementia or develop Alzheimer's or simply become sort of old and unable to take care of themselves anymore. That's often when these come into play. But they also come into play if you are young, if you are in a car accident and you are in a coma, if you have a traumatic brain injury of some sort, if you are just simply laid up and can't do things on your own, these documents can help you out significantly. The other time this is very, very important is if you are married and you have separate accounts of some kind. I've had frantic calls from spouses where one spouse was in a car accident or was injured or had a stroke or just had something happen, and the person who was injured had the bank account with all of the funds in it that are used by the family, and the spouse can't access those funds because they are not on the account. There's no power of attorney, and now we have a huge jumbled mess. You have to go to court. You have to do all these different things that are time consuming and expensive and could easily be avoided with this power of attorney. Okay, so on that side, you've got power of attorney, which allows someone that you name to make financial decisions on your behalf if you cannot make them. All right, this person has a fiduciary duty to you. Name someone to the spot that you trust. Okay, number two is medical power of attorney. It's gonna be the same thing, but for medical decisions specifically. Okay, often these people are the same. Sometimes they can be different. Sometimes there's a family member that's more attuned to making these medical decisions than financial decisions, and vice versa. Pick whoever you want. All right. It does not have to be a family member either. It could be a friend. It could be anybody that you want. Business associate. Just whoever's right for you. That's who you want to pick. But the key is picking someone. You get control when you create your own estate plan. The other thing that's going to be on the alive but incapacitated side is going to be healthcare directive. Healthcare directive is basically if you are a vegetable and do you want to pull the plug or not on yourself. Okay, and this tells your medical power of attorney what you would want to do if you were in that situation. One of the last things that you're going to have on this side too is if you have children that are minors, you have minor power of attorney, minor medical power of attorney. This is essentially who is in charge of your children if you cannot take care of them, okay? If you're married, obviously you're gonna have a spouse, but what happens if something happens to both of you? If you're both in a car accident and injured, who is going to step in and enroll the kids for school, take them to the doctor, just do the things that you need to do on the daily? That's what the minor medical power of attorney and minor power of attorney can do. Okay, that's the alive side. On the not alive side, on the dead side, we have a couple things that most people think of. The first is disposition instructions. These are just basically burial instructions. If you have specific things that you want to do, if you want a specific person to be in charge, this is the place that happens. Okay, that's pretty straightforward. The other thing that we have is the will. Will does a couple things. A, it names your personal representative. This is or executor. This is the person that is in charge of your estate. This person is in charge of essentially gathering your assets, determining your debts, paying your debts, and then distributing your assets as you have outlined in your will. The second thing that the will does is if you have minors, it will name your long-term guardians. This is if something happens to both parents, who steps in to that role, that parental role, and basically takes care of your kids. If you do not have this in your will, then a court will decide who takes care of your kids. And I always say, think about that person in your family member, or think about that person in your family that looks really great on paper, but you would never entrust your kids with, either because you have different philosophical beliefs of some sort, or they're just not very nice on the inside. Know that you can make a will, name the people that are in charge of your kids. It can be family members, it can be friends, it can be, again, anyone that you choose. But if you don't choose, a judge will make that choice for you. They will make their best choice that they can, but they don't know you. They don't know your philosophy. They don't know what's important to you, and they might get it wrong. The last thing that the will does is distribute your assets. Tells the world where you want everything to go. This is critically important if you are single and you don't want everything to go to your parents, for example. If you are in a long-term committed relationship but you're not married and you want things to go to that person, a will is critically important. They will be cut out. Any non-family member will be cut out of your estate if you do not have a will. And family members could also be cut out depending on where they are in the hierarchy of distribution. So a will is super important. Again, it just goes back to control, allows you to be able to make the choices, allows you to be able to do the things that you want to do. If you don't have these documents, you don't get to make these choices, okay? And they're not that difficult to put together. Last but not least is if you have some reason to want long-term oversight and management of your assets after you are gone, either because they are sizable, because you have minor children, because you have beneficiaries that you don't want to just give the money outright to, if you want to avoid probate, if you want asset protection after you're gone, then a revocable living trust is something that I would consider adding on. I don't consider that to be necessarily a foundational element of an estate plan. It is sort of like the bonus add-on, but it's something to consider. Okay, maybe tomorrow I'll get into the details of what a revocable living trust is and how it works, because we're getting to the end of the line here. But I wanted to take a minute and rehash the basics with you, give you an idea of what that takes, and stress the importance of getting this foundational plan done for everyone. Okay, it protects you, protects your family, protects your legacy. It protects everything. All right, that's it. As always, I hope you like this video. If you do, please hit the like button. If you have a question or comment, please leave it. I will answer it. If you know someone that needs to hear this, please share it with them. I'd be happy to talk to them. And if you want to talk more, or if you know someone else wants to talk more, you can do so by going to estatemeeting.com. Set up a time, talk to me over the phone for free, estatemeeting.com. Okay, that is it. I am Christopher Small. I am the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I'll talk to you again soon. See ya.